Hello, everyone. It's Larry Kotlikoff. Welcome back to Economics Matters, the podcast. I'm here with my guest, Alan Gassman. Alan is one of the country's top estate attorneys, and he's got a major practice in Florida. I want to just give you a little bit of his background. He's the primary creator and developer of Estate View software, which allows for the design, illustration, and analysis of estate tax, estate planning, and charitable strategies. So he, like me, is a software developer, and he's also the lead author of many books, including Gassman and Markham on Florida and federal asset protection law. He's got a whole long list here. It looks like 8 different books or so, maybe not, maybe 10. He's a frequent speaker for continuing education programs. He's published well over 200 peer-reviewed articles, including articles in Bloomberg, B&A, Tax and Accounting, Trust and Estates Magazine, Estate Planning Magazine, the Florida Bar Journal, Forbes, and Lineberg Information Services. He's had a very successful career building up his practice in Florida. And he has a law degree and a master's of law as well from the University of Florida. The master's is in taxation. He also has a business degree from Rollins College, and he's board certified by the Florida Bar in estate planning and trust law, and was inducted into the Estate Planning Hall of Fame class in 2021. And received the accredited estate planner designation from the National Association of Estate Planners and Counsel. He's maintained a AV rating from the Martindale-Hubbell for over 20 years, and is listed in both Best Lawyers in America and Florida Super Lawyers. So, Alan, welcome. Thanks so much for joining us. Maybe you can fill in your bio a bit and tell everybody how you went from being a 5-pounder wherever you're born, or 8-pounder, to getting into law and getting into estate and trust law, and how your career just progressed, and why you find this an interesting area to pursue for people. Because we have a lot of young listeners as well as older ones who are interested in people's kind of life courses.
Well, one thing I remember was in 7th grade, I got a D+ in chemistry. And my parents went to the chemistry teacher, Mrs. Denton, and she said, "You realize that Alan brings the Wall Street Journal into chemistry class every day and reads it cover to cover instead of listening to my lectures on chemistry. So he really needs to change that." So I was very interested in business, and I was interested in the mathematics of business, and I was interested in how to be successful in business. And I read books like Think and Grow Rich by Napoleon Hill and other literature, and decided that I would be a good match for being either a CPA or a lawyer. And worked for a law firm in high school and then college, and that seemed like a good gig. And it's interesting, and if you work hard in any profession, the difference between being average in that profession and being really good in that profession is really just work ethic and organization. You don't have to be any smarter than anyone else. And every 5 or 10 years, I reach a slightly higher height, and I've been doing it for 41 years now and enjoying the ride a lot.
Cool. So tell us about how you got into software development.
Well, in doing estate tax planning and estate planning in general, you have to run the numbers. It's very mathematical. And most people have been estimating the numbers off of the top of their heads and not really running the numbers exactly. And there's various multiple things happening at the same time in an estate tax plan. So there were some software programs that weren't doing a good job at it. And my son-in-law is a software programmer. So he was in his 2nd year of his career as a software programmer that we sort of made this a family hobby. that grew into a business.
I see. So are lots of estate attorneys using your software at this point?
Hundreds, not thousands, but hundreds
Uh,
are using it and enjoying it. It's enjoyable and it's nice to get to a better answer for people.
So what kind of things can it calculate that for people? First,
Well, it can show people where they can expect to be if they don't do any estate tax planning. And then
mhm.
it can show them the 7 or 8 most common strategies and how those would work for a particular family so that they can choose which strategies they want to use and which strategies they don't want to use. And then it shows what happens if you use the strategies at the same time, because one strategy will impact the use of another one.
Got it. So it's interactive. So tell us, maybe we could have a conversation about these strategies for a bit, because I think, the idea of getting together was to kind of give people uh, in this listener community an idea about estate planning, the ABCs, but also for people that are even more sophisticated in terms of they've already gotten the basics down. Uh, what are the pitfalls and traps, and what are the things to both look out for and look for in terms of having an effective uh, uh, path towards disposition of your assets in a way that you really want, not in the way that maybe Uncle Sam would like.
Right. Well, first of all, separate and apart from the estate tax planning is the estate planning. Where my will may direct how my assets will pass, or if I want to avoid the court process of probate, which is what happens when you die with assets in your personal name, whether I will use a trust or trusts. And then between a married couple, do I just leave everything to my wife and I hope that she'll do the right stuff and not have it taken away from her? Or does she leave everything to me and not wonder or worry whether I might remarry and leave these assets to my next spouse? Or do we have things become irrevocable on the first death so that I'm protected from myself, that I won't be able to give them away? And will my creditors be able to take them? So there's a lot of considerations that aren't normally attended to. Most people just think, oh, I'll leave it to my spouse, and then on the second death, it'll go in perfect shares to our children, without thinking about, well, if it goes to my child, should it go to her personal name where she may lose it in a lawsuit or a divorce, or should it go to a special trust for her? So it can get very complicated and very interesting.
I see. So is this something that middle class people should be thinking about, or is it more something for people with high net worth?
Well, somebody who has $1 million of assets and wants to see those that $1 million of assets properly handled for a surviving spouse and then properly handled for descendants can do this careful planning. You don't have to have 10 million or 100 million. It's just a matter of whether you have some sort of nest egg that you want to protect.
I see. And what's the typical cost for an estate plan if you're if you're, let's say, setting up a trust arrangement?
I would say probably most revocable trust and will packages for married couples in the United States, probably $2,000 to $3,000 is probably what it takes to do a conscientious job for a you know I'll say middle class million, 2 million, $3 million net
Okay.
worth people. If you try to do it on your own, you're probably going to mess it up. And
So
if you do it less expensively with wills, then you may face higher probate costs and higher risks of losing assets to creditors and subsequent spouses. A good estate plan could easily cost $10,000 once you think through all of the different implications. There's no one piece of software or a chat GPT 4.0 that can do a thorough estate planning job. It takes a lot of custom drafting sometimes. So it can be expensive.
So now you mentioned revocable trusts and irrevocable trusts. Maybe you can explain the difference and also probate. So you're saying that if you have a trust, you don't need to go through probate, uh, or your heirs do not. Uh, is probate that big a deal?
Probate is usually not that big of a deal, but if I die with an asset in my name, my will says my $1 million bank account at Wells Fargo will go to Marcia. But that Wells Fargo account is in my personal name and there's no pay on death feature. So now Marcia has to go to the probate court, get the judge to decide that my will is a valid will. She has to get a bond so that she can be appointed my personal representative. And if she steals the money, the bonding company handles it. She's got to make sure all my bills are paid. She's got to make sure all my taxes are paid. She's got to show the judge that that occurred. She has to give certified notice to any creditors. And then after 2 or 3 years of paperwork, she's done. So that's probate. That could cost $1,500. It could cost $5,000, depending on how much work is involved. A lot of times a client dies with a very disorganized situation, and we got to go into their house and go through boxes of stuff and figure out what was what. And that's where probate can get very expensive. Now, on the other hand, if I have a revocable trust, just a piece of paper that says this is the Alan Gassman Revocable Trust, Alan's the trustee, it's held for Alan's benefit, Alan can change the trust anytime he wants. On Alan's death, the assets go to Marcia. Then I title my Wells Fargo account into the name of that trust. And then when I die, she walks into Wells Fargo with a death certificate and a copy of the trust, and she gets control. And she didn't have to go through that probate process. So that's a definition of probate and a brief discussion of what a revocable trust is.
Revocable trust. Okay, and you could be the spouse heir could be the trustee of the revocable trust.
I can be my own trustee while I'm alive and well.
Okay.
And then the trust can provide that if I can no longer serve as trustee because I get dementia or I die, then the alternate trustee comes in and takes control and has possession and use of all the assets that are titled to the trust, which could be my home, my office building.
And
And
that would be distributed, let's say if you were to pass or they would be distributed according to your will.
according to my trust document,
Trust document, I see.
I'll typically have a will that says on my death, move everything into my trust. So if anything has to be probated, it goes into my trust. And then the trust agreement provides the operating instructions, which most commonly when I draft it, says that my spouse will become the beneficiary of the trust for life and receive what she needs for health, education, maintenance, and support, but not more than she needs. And then creditors can't reach in, her next husband can't reach in, and it can be immune from estate tax when she dies. So leaving assets in trust for your beneficiaries instead of outright can protect them in many ways.
So when you say immune from estate tax, so let's say you had a house and you passed, it was in the trust and you then are this second spouse to survive and then you pass. Can you provide it to your kids with a step up in basis?
Yes,
Okay.
there can be you're going to get a step up on the death of the first dying spouse, and then maybe a step up on the second death, depending upon the circumstances of the plan.
Let's talk about retirement for a minute. It's something Americans think about regularly. Ask yourself, how financially secure do you really feel? Do you have enough money to retire? How much is really enough? And if you don't have enough money, how can you possibly find that extra money before you do retire? These are all tough questions. My retirement software, Maxify Planner, is the powerful online planning tool that takes the guesswork out of retirement. It weighs your assets against your fixed expenses to calculate how much you can safely spend every year for the rest of your life based on when you decide to retire. And it shows you safe ways to find more money. Maxify makes a complicated problem like retirement planning simple. It's accurate, easy to use, and produces what you really seek, peace of mind. So make the smart choice and visit Maxify.com today. Don't miss this opportunity. That's Maxify with an I, M-A-X-I-F-I, Maxify.com. Now let's get back to the podcast. Would that be true if you did not have a trust?
If you don't have a trust, if I die and leave it outright to Marcia, there'll be a step up when I die. And then when Marcia dies and leaves it to our children, there will be a step up at that time.
I see. Okay. And got it. So that's about a wash. So, but where's the estate tax gain from having a trust versus not?
Well, the estate tax, first of all, the federal estate tax exemption right now in 2025 is 13,990,000 per person. So let's call that 14 million.
Mhm.
So if I die and I leave Marcia 25 million in assets, then when she dies, if that's grown to 75 million, because you know it could double every 10 years, then on her death, the estate tax is going to be based upon 75 million. On the other hand, if I die and I leave 14 million to a trust for her lifetime benefit, and she inherits only 10 million, then that trust for her benefit with the 15 million, if it doubles twice, it'll be up to 30 million, 60 million, and it will never be subject to estate tax when she dies. So that first technique is called a credit shelter trust or a bypass trust, that on the first death, we like to leave assets in a trust that benefits the surviving spouse, but will not be subject to estate tax in her estate. And it's also protected from creditors and divorce claims if she remarries or if she gets in a car accident. So many people should not be leaving assets directly to a spouse, but in trust for the spouse.
Okay. And is this also free of state estate taxes?
It can be, yes. For example, the New York estate tax level is about 7 million. So if I die a New Yorker, I want to make sure I'm leaving the first 7 million to a bypass trust for my spouse, which will never be subject to the New York estate tax or the US estate tax on the second death.
I see. And what about irrevocable trusts? How do they differ from revocable trusts?
Well, an irrevocable trust is a trust that I set up that I can't change. And this year I could put, say, $5 million of investments into an irrevocable trust for Marcia and our children. I use 5 million of my 14 million allowance, which brings my allowance down to 9 million. And then that trust doubles to 10 million in 10 years. Another 10 years, it doubles to 20 million. Another 10 years, it doubles to 40 million. And it's never subject to estate tax. And I only used 5 million of my exemption. So gifting today to a trust that can benefit your spouse and descendants can be a very good idea. And these are normally called spousal limited access trusts, because Marcia could be the trustee and have the power to receive assets as she reasonably needs. But if she doesn't touch it and lets it grow, it can be a very important part of our financial world.
So if you have your money, or let's say your house in the irrevocable trust, does that get a step up in basis if it were to be sold?
Usually the irrevocable trust causes you to not get the stepped up basis. The
Okay.
law is not clear in that area. Many of us believe there is a step up depending upon the nature of the trust, but the IRS says there is no step up when the second beneficiary dies.
I see. So that's the disadvantage. So the big advantage of there is a clear disadvantage with respect to the step up, but the advantage is that compared to a revocable trust, what is the relative merit of the irrevocable versus the revocable?
It will be outside of my estate for federal estate tax purposes.
Oh, but I thought the revocable trust was outside, but that's not the case?
No, the revocable trust avoids probate with the probate court, but the revocable trust does not avoid federal estate tax or creditors.
Or state estate taxes?
State estate tax, that's correct.
I see. So, got it. So the irrevocable trust is really uh, uh, the way to avoid estate taxation, but it comes at a cost. It comes at a price in terms of not getting the step up in basis.
That's right. I will add that if you have an elderly person that you would make a beneficiary of that type of trust and they don't have a lot of assets, then there can be a step up in basis when they die. So I can set up an irrevocable trust for my wife and children and make my father-in-law a beneficiary of the trust and set up what's called a power of appointment so that when he dies, there would be a step up while Marcia and I are still alive.
Oh, okay. Uh, so he's a beneficiary. So there's a step up in basis for the assets that are allocated to him.
He can be given the power to direct trust assets to creditors of his estate under a fancy provision, and that can cause the trust assets to all receive a step up when he dies, even though he never receives any benefit from the trust because of the way the Internal Revenue Code reads.
So there's some special workaround that you're saying if you have an older relative who might pass, you can actually use an irrevocable trust to actually get the step up in basis that would then provide more resources for your children
That's right. And for you,
and for you. Okay. Is there any limit to the let's say a spouse using proceeds of the revocable trust or the irrevocable trust for their benefit? Does they, you said the spouse, surviving spouse could be the trustee. Could they be the sole trustee?
yes,
So then they can determine exactly how to use the resources. What about the irrevocable trust? Can you have a sole trustee there too?
yes,
I see.
yes.
So so you're kind of suggesting that everybody should have a trust.
Well, I think everyone should consider a trust if you're concerned that your assets may be lost to a creditor or a subsequent spouse or a divorce, then it makes sense to consider a trust.
I see. Okay. And so this has kind of very quickly gotten to the pretty good picture of no trust, probate, revocable trust, no probate, but no tax gains really, but you get the step up of basis, revocable trust, irrevocable trust, you avoid estate taxation, but you can potentially lose the step up in basis, except there might be a workaround. So we got a pretty good picture in very quick order because you're the master teacher, right? On estate tax, estate law and estate practices. I can tell from just a quick sense talking with you. But are we missing anything? Is there some aspect of uh, the story that we've left out? Or are there things that are there? And if there isn't, if we kind of covered the basics, maybe you want to tell us for a few minutes some horror stories that you've experienced over the course of your day that can help kind of get people, um, make people more aware of the downside of not doing estate planning.
Sure. Uh, a month doesn't go by that I'm not involved with some family having issues with a trust system. So reading the trust carefully and making sure that it says what you want is important. And then deciding where things are going to go so that the trust is fully funded on the first death is a second important thing. People die, and there's this trust that's supposed to receive their life insurance, but they never made the trust the beneficiary of the life insurance. Or they die with a beautiful trust that was going to avoid probate, but they never put their assets in the trust. So it doesn't avoid probate. But I think what's more important than that even is to think through, you know, when one spouse dies, what's going to keep the surviving spouse from leaving everything to a next spouse who takes it all, or losing everything to a housekeeper when the surviving spouse gets dementia? Or does it eventually get left to the children and the child loses it? Maybe they don't manage it properly. Maybe they're spendthrifts. Maybe they're gamblers and they don't really invest it reasonably. So quite often we'll talk to the clients, the spouses, about, if one of you dies, would you like a portion of these assets to be in an irrevocable trust so that the survivor can't have it taken away from her? And would you like to require her to be co-trustee with her choice of a trust company or one or more individuals named in the trust so nobody can try to take it away from her? And on the second death, do you want it to go outright to your children or lifetime trusts? And if lifetime trusts, your child just be co-trustee with her choice of a trust company so she doesn't foolishly spend it, borrow it all, and loan it to her spouse to set up a restaurant company that's going to go under, et cetera, et cetera. So if you want your wealth to last and really be used for its highest and best use and not be wasted away, the careful trust planning is certainly called for.
So the trust company, it sounds like that might be a third party company that would, have you heard any horror stories about the trust company not being trustworthy?
Yes, but the stories are not true. When I draft a trust, it says that on the death of spouse one, spouse two will serve as co-trustee with her choice of any trust company in the United States. So she can go interview 10 trust companies, which may include Vanguard, Fidelity, Charles Schwab. Those are all discount trust companies. Peak Trust Company is another very good trust company. And they will serve as co-trustee with that surviving spouse, and they can be fired by the surviving spouse and replaced by another trust company. So when a trust company has to negotiate their fee schedule to be competitive, give you their best trust officer to do the work, and they know they can be replaced, you do not see any horror stories. The horror story would be if you died and said, ABC Trust Company will be the trustee, no matter what they charge, and no matter how bad a job they do. So the moral of that story is always give somebody the power to replace the trust company so that the trust company has good motivation to do the right thing.
I see. So, I mean, in the extreme, the trust company could block your use of funds or some survivors' use of funds, maybe the children's use of funds, and say, no, you can't take this money out, and just charge fees through the end of time. That's really the worst case scenario, right?
That's the worst case scenario. You rarely see it. What you see instead is a beneficiary who's unreasonable, who says, well, grandpa left me the 10 million. Can't I spend $1.5 million a year? Well, no, because you'll run out. 4% of 10 million is 400,000 a year. You're going to have to make do on 400,000 a year, but that's completely unfair. I want more than that. And then go tell all your friends that the trust company's a terrible thing. That's more often what we see than
And
something bad that a trust company did.
Want more money, less risk, and a better life? Buy Money Magic, a new book by Lawrence Kotlikoff, Boston University economist, personal finance expert, and best-selling author. Whether it's education, career, marriage, housing, investing, retirement, Social Security, IRA, or 401k decisions, Money Magic delivers scores of secrets to raise your living standard. Financial journalist Jane Bryant Quinn says Money Magic is a must-read, Nobel laureate George Akerlof says Money Magic is quite probably the best financial advice book ever written. Financial guru John Malden says, "You'll love this amazing book. It's full of wit, wisdom, and startling paths to a better financial life." And columnist Scott Burns calls Money Magic a funny, brilliant read, offering wildly powerful, unconventional choices that can literally change your life. Get Lawrence Kotlikoff's Money Magic today at Amazon, Barnes & Noble, and independent booksellers.
What would the trust company potentially charge for managing or somehow co-managing 10 million bucks? Were we talking 2% of assets or something like that?
It may be 1% on the first 2 million and then 0.5% above that. It does vary significantly, but it's usually less than what we see clients often pay brokerage firms to manage portfolios. So in other words, if you wanted a fiduciary managed portfolio at one of the well-known brokerage firms and they charged you a percentage, that's about the same percentage that a trust company would charge to manage the assets and administer the account, get to know the family, pay expenses and things like that. It may be 1%, or it may be less than 1%, depending upon how competitive they are and how much there is in trust.
So, personally, I take it you have your own trusts for you and your wife.
Yes.
Revocable, irrevocable, or you want to?
We have revocable trusts for the assets that are outside of our irrevocable trusts, and we have an irrevocable trust. And when one of us dies, the survivor will serve as co-trustee with my choice of a trusted lawyer friend, a trusted CPA friend, or a trust company, so that I, don't get pushed around or taken advantage of in later years.
And what happens if you're, I guess there are scenarios in which you must have kind of some concern that you might outlive your trusted CPA friend. And,
Right.
and
Right.
then,
And that's why one of the choices is a trust company of my choice, and that I can change that trust company at any time. So I might start with Vanguard Trust Company, and then after 5 years, I may not like them. I may switch to Fidelity Trust Company. 5 years later, I may not like them. I may switch to another one. But there will always be reputable trust companies available in the United States.
I see. But if you got dementia, let's say, at what point do you get declared unable to kind of manage your trust, and then the trust company is in charge and there's nobody else to switch the trust company? I'm just trying to think through worst case stories here.
Right. If I get dementia, then I'm no longer a co-trustee, but the alternate individual co-trustee can be my children or a best friend. So if I get dementia, then my best friend becomes co-trustee with his choice of a trust company, and he can replace the trust company. Then if he can't serve, it could be my children. So I always have a lead individual who's co-trustee with their choice of either another individual or a professional or a trust company, so that you have checks and balances.
I see. Okay. All right. So this can be done in a safe way, is what you're saying, and not for enormous expensive. It doesn't have to be enormously expensive. And why did you choose to make certain assets, put certain assets into the irrevocable trust and certain into the revocable trust? And why would somebody choose to have two types of trusts?
Well, the assets I've put in the irrevocable trust will never be subject to federal estate tax.
Right.
So when it doubles and then doubles again and doubles it again, our children won't have to pay estate tax on that. And that's why most irrevocable trusts in the United States are formed by wealthy individuals, to avoid the estate tax. The other reason is when my father-in-law passes away, I'm going to get a brand new income tax basis on the assets in that trust. Third, if somebody sues me and they sue Marcia, they can't reach into that trust. It's creditor proof. So those were all reasons to do an irrevocable trust.
And why didn't you, okay, so I got but why did you not put everything into the irrevocable trust?
Because I want to have control. I may want to change things around.
I see, okay. So this gives you some flexibility.
Right. The assets that I plan to spend for myself would stay in my revocable trust.
So right now, if you had everything, let me just presume, I don't know if this is the case, but if you had all your assets, everything, including your checking account, in one of these two trusts, do you have to go through some rigmarole to go pay a bill, or
No, no, if I have my bank account in my trust or payable on death to my trust, I'm still the signer on the account individually. People don't necessarily know that the account is in a trust. So it's really not an inconvenience. I mean, setting it up can be an inconvenience because I'd have to go to my bank and say, hey, I've set up a trust. I want to either put my checking account in the trust or I want my checking account payable to the trust automatically on death. And then I have to sign something to make that happen. So it could be a day's work, but it can save a lot of time and trouble.
I got it. Well, cool. So I'm kind of running out of questions because I think you've done such a great job covering the turf. Tell me, let's talk about any things I've missed, but also let's talk in more generally about your interest in personal finance and issues that you see. Uh, uh, Say you're more interacting with high net worth people than I am, and so maybe you have some kind of advice, general advice, or concerns about how they're handling their situation that's independent of state and tax issues, estate tax issues and estate and trust issues.
Yeah. Well, first, let me emphasize that everybody should know what you own, how it's held. Is it joint? Is it in your name? Is it in your spouse's name? What a creditor could reach if you were in a horrific car accident. You should know those things, and you should also know how much liability insurance you have. This morning, my meeting was with a gentleman who had $1.5 million of liability insurance, and sorry, but that's not enough for the accident he was in. So when you get with a lawyer, get with an estate planner, what do I own? How is it titled? And if I get sued for a car accident, what do I lose? What does my spouse lose? If my spouse dies, where are these assets and what's my access and what's the access to my next spouse? You should, be asking those questions. Now, from a federal estate tax standpoint, or if you're in a state like New York or Illinois or Massachusetts that has a state estate tax, then the question becomes, when we die, will there be a federal estate tax or a state estate tax? And if there is, what can we do now to get around it? And that's where the software can come in to show clients who are over that $30 million per married couple federal estate tax threshold, what they can do to reduce the exposure or completely avoid the exposure.
Now, right now, if you pass, uh, let's say and you give all your assets to your spouse, there's no estate tax due. There's I guess, an exemption or deduction for anything you give your spouse. So it's really the second to die where the estate tax comes in, right?
That's right.
And is that true with state estate taxes as well?
Yes. If you leave the assets to your spouse, there will not be a tax at that time, but then everything will be subject to tax in your spouse's estate when they die, which is why you may want to fill up one of those bypass trusts on the first death.
Or maybe the surviving spouse moves to Florida where there's no estate tax?
That's
State,
right. Well,
state
then
estate tax.
right. And then you just have the federal estate tax. That's right.
So this is an important, I think, strategy for how many states? There's about 7 states that have their state estate tax. I happen to live in Rhode Island. They have a state estate tax. It's a pretty nasty one. Massachusetts, everywhere around New England, it seems like it's maybe, with the exception of New Hampshire, has a state estate tax. Uh, and then other parts, maybe California does as well. I'm not quite sure.
None in California, Texas, or Florida.
There's none in California. Okay.
Right.
Texas or Florida, but the other states have state estate taxes? And if you go to like Oklahoma, they can't have one, no?
Yeah, I don't think so. It's mostly the northeastern blue states,
Yeah,
the federal estate, I mean, the state estate tax. And a lot of people do escape them by moving to Florida or moving to Texas. That's why so many people live in Texas and Florida. A lot of, very wealthy people just don't want to pay that state estate tax.
I see. Yeah. And so uh, people should be checking their umbrella policies to begin with, right? Like,
Yeah, the umbrella, at least $1 million of umbrella liability insurance, which goes over your car insurance and over your homeowner's insurance. But they regularly go up to 5 million. So you could say how much for $1 million, how much for 2 million, how much for 3 million, how much for 4 million, how much for 5 million.
okay.
Most of my wealthy clients have 5 million of umbrella coverage.
Let's talk about retirement for a minute. It's something Americans think about regularly. Ask yourself, how financially secure do you really feel? Do you have enough money to retire? How much is really enough? And if you don't have enough money, how can you possibly find that extra money before you do retire? These are all tough questions. My retirement software, Maxify Planner, is the powerful online planning tool that takes the guesswork out of retirement. It weighs your assets against your fixed expenses to calculate how much you can safely spend every year for the rest of your life based on when you decide to retire. And it shows you safe ways to find more money. Maxify makes a complicated problem like retirement planning simple. It's accurate, easy to use, and produces what you really seek, peace of mind. So make the smart choice and visit Maxify.com today. Don't miss this opportunity. That's Maxify with an I, M-A-X-I-F-I, Maxify.com. Now let's get back to the podcast. Okay. And just to make sure we're dotting all the I's and crossing all the T's, everybody should have I guess a living will where they specify what they want to do if they become incapacitated, when letting somebody pull the plug, and a healthcare proxy, and a will to begin, wills. Anything we're missing in terms of these kind of basic documents that need to be?
First of all, on the healthcare power of attorney or the healthcare proxy, put down multiple names. Don't just put your spouse, alternate your children. Put down your spouse and your children and your best friend. Because if you're sitting there in intensive care, the first person who walks in the room needs to be able to act for you. So appoint a strong advocate who feels comfortable walking into a hospital and fighting the bureaucracy to keep you alive. That's the healthcare power of attorney. The living will is a document that simply says you can pull the plug when there's no hope. When I have an end-stage condition, quality of my life is terrible, you can pull that plug, normally only with the consent of the healthcare proxy. Then there's a durable power of attorney where you give your family members the ability to make financial decisions for you. So almost everybody should have a healthcare proxy, a living will, and a durable power of attorney, also a last will and testament, and then maybe a revocable trust. Maybe for a married couple, it's a joint revocable trust. That depends on circumstances. Different people are different and need different things.
Okay. And what are you seeing in general, kind of apart from these issues, with the financial decisions of wealthy clients?
As far as which decisions?
Well, like investment decisions. I mean, I'll give you an example. You know about our software because I have talked about it with you on your podcast about Maxify Planner. What's the name of your software, by the way, so we can make sure everybody...
Estate View.
Estate View, okay. And can people buy this and use it themselves, or do they really need to have a professional run it?
Probably best to have a professional. they could play with it themselves. They might do themselves harm if you rely on it. So it'd be best to use a professional.
Got it. Okay. So, so one of the things that we've moved into with our company is to help people who don't necessarily want to run software by themselves, to basically be a co-pilot with them, or I have something I call a concierge service where I assist people in the use of our software. And lately, I've I have people of all walks of life that can, uh, just all over the place. But I've noticed that the higher net wealth people, I'm seeing a similar pattern, which is that they have uh, $7-10 million of wealth. They're in their 70s, and they might live in upstate Michigan, not have a lot of ways to spend their discretionary spending. And our software says, here's what your discretionary spending can be. That's the first thing it shows, and it's up here, and they're spending down here once we do a little, do some budgeting in the tool to look at what they're actually spending apart from their fixed expenses on housing and taxes. So they're spending less than they possibly can, really. I try to talk to them about, well, you're able to spend. They're happy to hear this, but you're able to spend more. Would you want to spend more, but take more vacations? Well, no, we're actually taking 3 vacations this year. That's plenty. Well, what about concert tickets? Well, where we live, there's not too many concerts. Better restaurants? No, can't spend more. Clothing? Nobody wears fancy clothes here. So then I start talking to them about and I started asking them about how they're invested, just because of general curiosity, because I can't give investment advice, but they tell me 70-30, let's say stocks and bonds. And I said, well, it seems like, that you're not different from a lot of other people I've been interacting with, but it seems like there's something you might be missing here, which is that investing in risky assets has no upside for you because you're spending at below your maximum as it is. And the only thing that can happen from investing in risky assets is downside risk. There's no upside risk to you personally in terms of your living standard. And so these assets and then, we can run our software with a spending ceiling and show them the impact of, how much the estate at the end would be and along the way. But I try and, point out that maybe the assets that they have here are actually their children's assets, and that they're actually putting their children's assets at risk, not their own assets at risk. And then a light bulb seems to go off. And then I start to talk about, and by the way, do your kids, are your kids in lower tax brackets? And if so, maybe accumulating money, letting them accumulate money by giving them gifts, making them gifts now, and letting them pay taxes on the income at their rate rather than at your rate makes more sense than now. To react to that, what's your take on that?
Well, that's all great advice. Let your kids start their nest egg if they're not going to waste it.
Yeah.
And most of us, or most people who spend less than they can, are being responsible adults, and they're doing it for their children and grandchildren and great grandchildren. So
Right.
that's all fine and good.
Right. So yeah, so I guess there's an issue of trust in your kids and whether they'll be responsible with the money or whether they'll squander it. But these are older people and their kids are older, grown adults, and probably leaving money to your kids when they're 70 versus leaving it to them when they're 40, and there's, and it can be meaningful to them in terms of maybe extra ballet lessons for the children or violin lessons, whatever it is. So I see that kind of behavior at the high end. At the low end, I have I see a lot of people that are just afraid to plan because even my own colleagues, economists in my economics department, I think there's some anxiety, even though our software is kind of geared towards figuring out how to save them taxes, how to make them more, Social Security benefits, how to, help them figure out what to do with Social Security, and to also kind of limit their downside risk to their investing because we have investment tools. But there's this anxiety that people have, and it probably also extends over to estate planning of just probably putting it off and not, and then worrying. It's not that the anxiety goes away. They're still worried underneath it all. They just can't find the time. And sometimes they're leaving a lot of money on the table, or leaving it for Uncle Sam. Do you have any insight into the how you can break through that psychology? I'm,
How to get people to be responsible and
yeah, I mean, well, I try and think about our software as kind of fun, as like a, a video game for older adults. I don't want to call it an older adult video game, but uh, if you can sit there and play around and see how you can save money or save estate taxes in your software case, it seems like that's
yeah,
kind of a fun game.
yeah, when you run the numbers and you show the client how the numbers work and how these vehicles work to protect these assets for future generations, both from creditors and from federal estate tax, usually the lights comes on and the people will go forward. But they're busy going on vacation and going to this and doing that, and sometimes they don't get around to doing the estate tax planning, and then they get a heart attack, and then it's too late, and a lot of sad stories. So, and I think that's why you see investment advisors charging so much, because they have to spend so much time and effort on marketing to get people to be responsible, that they
That's
then go and charge a lot to pay for all the marketing, right?
right. And we still have a good, probably half to 60, 70% of the households not doing any planning with anybody.
That's
Uh,
right. It's a travesty, and there's no, I have a travesty. I can't get to all the wealthy families to get their estate tax planning done, and you have a travesty. You can't get to the, middle America to help them decide what their spending should be, because people are just not inclined to be responsible and reasonable all the time.
it's funny, they are in general, but in this particular dimension, economists are very kind of pretty careful, nerdy type people who are, you would think would take a lot of care with their finances, but they, even they have some psychological barrier here. Uh, but something usually triggers the decision. So it might be retirement, it might be a health shock, it might be uh, yeah, yeah, it's usually one of those two things. It might be taking Social Security. They get to some point where they get triggered. Now we got to do it. And yeah, they should have been planning all along because they may have saved too little, or they might actually have spent too little. That's the other thing. They could have kind of squandered their life, their pleasure, because they were overly concerned. And that's generally what comes out here, that people, a good chunk of people are underspending relative to their capacity. And even when you
Yeah,
put
yeah.
even putting contingencies for nursing home costs and things of that nature, I find.
Well,
So
or it just goes back to Freudian stage. They grew up and at dinner, their parents said, spend as little as possible, spend as little as possible. You never know if you're going to run out, spend as little as possible. And that's what your brain continues to tell you. You may have $200 million net worth, but your brain's still telling you, I better not spend money. I better not spend money. I better not spend money. And they don't.
yeah,
That's just part of the human nature of it all.
yeah. Well, listen, Alan, this has been lots of fun as ever. This is, and I'll certainly want to have you back on down the road, but this has been great. I want to thank you. I've had several people come who are state attorneys talking about these issues. I have to say, I think I don't want to rank anybody, but you've been terrific. Okay.
Just try to use common sense and do the right thing for people. And
Yeah.
that's sometimes you have to force that on them, right? Other times it comes natural. But thank you very much for everything you're doing. Your software is fantastic and as you said, very interesting as well.
Well, glad you're having fun.
All
Okay.
right.
Take care.